Yes, can you mention it from that side? Yes. Yes.
My lord, the first appeal to me.
Hearing we are not taking up now.
No, my lord, I am a
know,
senior citizen, but since
appreciate, but we,
2024,
there are too many appeals. We can't take up. Yes.
I'm mentioning one matter for inclusion under heading to be mentioned, my lord.
Why?
For regularization of the Wakalatnama, my lord.
my lord, it cannot
Application and order for 20, please hand over.
File has come on 17th of February 2020.
এটা দিয়ে দিন লিস্টে দেখে দিন
application for early disposal and calling for the
please hand it.
Members of the bar, may I raise
Yes.
something?
Yes.
Since virtual mode has been introduced, let the connection be given at least 10:20 a.m.
You don't have any direct control on that.
Yesterday, I tried to mention I was connected at 10:40.
Yes, we saw that. Yes, in the middle of the.
Kindly, what I was praying, if you will also
So what is it, we appreciate fully, but we cannot look after everything.
I understood from your my lord's officer that only after taking seats of the honorable judges we connect. Well, we are present here since 10:15. So virtual mode should maybe at 10:15. There will not be any problem for the
একবার
officers.
ওনাকে ডাকুন তো নিয়মটা কি তাই হ্যাঁ একটু আগে যদি ওরা অ্যাপ্লাই করে দিয়ে দেবেন কানেকশন কিন্তু কানেকশন দিয়ে মিউট করে রাখবেন আমরা বসার পরে তারপরে হ্যাঁ ঠিক আছে 25 দিয়ে দেবেন ঠিক আছে
Grateful to you, Lord.
থ্যাংক
Will be permitted to,
you are repeating yes you
May
no we'll hear her
will
yes
be permitted to mention, my lord, for my lord, their order has been passed, my lord.
what are you mentioning for
For my lord's correction of the order.
yes please handle call on the list. Accordingly, FAT number 311 of 2018 is dismissed on contest without any orders to costs against the respondent number 1 and ex parte against the other respondents, thereby affirming the impugned judgment and deemed decree dated March 28, 2018, passed by the learned additional district judge, 6 Court at Alipur, District South 24 Parganas, in original suit number 6 of 2012, whereby probate was granted in favor of the respondent number 1 in respect of the last will and testament of late Kumud Ranjan Datta. Can 1 of 2018 also stands disposed of in view of the above.
Grateful to your lordship.
Thank you.
Very happy.
Your lordship, for item number 2 and 3, they're both appeals arising out of title suit number 1990 of 2022.
Can you please just take the microphone a bit closer to you? 2 or 3 একসঙ্গে বোর্ডে দেখান. Yes.
Your lordship, both of these appeals are arising out of the title suit number 1990 of 2022. The title suit has been dismissed for default in the learned court below.
Dismiss or default by FMA? Arbitration, arbitral award.
Yes, your lordship, I think so. Your lordship, for the first
This is what? It's under section 37 of the Arbitration and Conciliation Act.
no, your lordship. Your lordship, this was an injunction application. Your lordship, the item number 2, I am for the respondent.
2 is Latif Gain
Yes,
versus.
your lordship, I am for the respondent. Item number 3, I am for the petitioner. We are defendant in the title suit in the lower court below.
So why is it classified as an arbitral? Oh, subsequently it has been changed. Also, what do you want now?
Your lordship, since the matter has been dismissed for default in the learned court below, the appeals have become infructuous. So, lordship,
Say that. The
lordship,
main suit has been dismissed for default.
yes, your lordship.
So you want to have these dismissed as
Your lord,
infructuous. So
yes.
you are for the appellant in both the matters.
No, your lordship, I am the appellant in the item number 3.
What about 2? We have called on 2.
Yes, your lordship. It's this. It's arising.
Have you got a copy of that order dismissing the suit for default? Hand it over.
Your lordship, may I pray for one liberty?
Yes.
In case the title suit is restored in the learned court below, may I have the liberty to come back to this court?
You are a respondent, you are saying.
In the title suit below, I am the defendant. Here,
Here, the appellants, you are not the appellants.
in item number 2, I am the respondent.
Acha,
In
acha.
item number 3, I am the appellant.
Very good. learned counsel appearing for the you are for Lotip Gain.
For
Tata.
Tata Capital.
Learned
Tata
counsel for
Capital.
the appellant in FMA 305 of 2024 and respondent in FMAT 317 of 2023 submits that both the appeals arise in connection with the same title suit, which has since been dismissed for default, thereby rendering the present appeals infructuous. Full stop. Server copy of the order dated February 18, 2025, passed by the learned trial judge, dismissing the suit for default, is also handed over in court and kept on record. Full stop. In such view of the matter, FMET 317 of 2023, along with the connected applications bearing CAN 1 of 2022 and CAN 2 of 2022, as well as FMA 305 of 2024, along with the connected application bearing CAN 1 of 2023, are dismissed as infructuous without any orders to cost. Full stop. However, in the event the suit is restored subsequently along with the impugned orders in the present appeals, liberty is granted to the appellant in each of the matters to prefer a fresh appeal, is if necessary. Thank you. There are several defects in the appeal as pointed out in the office report dated March 20, 2025. So first, the memorandum of appeal is barred by 1358 days of delay. So despite the directions of the court dated February 13, 2023 and December 1, 2023, no fresh application for condonation of delay has been filed. Moreover, the classification of the appeal is erroneous in words, the name of appellant number 3 does not tally with that of the certified copy of the decree, and the date of signing the commissioner's report is required to be deleted from the preamble to the memorandum of appeal. Next para. The appellant, the learned advocate for the appellants is directed to remove the defects within a fortnight from date, in default, the matter be listed under the heading Loazima for final orders on April 10, April 16, 2025.
I am appealing for Dismissal 3A.
The other respondents have been served.
According to my lord's direction, I have served upon the erstwhile learned advocate because all the allegations are against.
One of the envelopes has returned as deceased.
Yes, that has already been substituted in the court below.
No, so here his heirs are on record.
No one already on record.
So why did you send on this person again?
Name has not been changed because it is changing.
That has the name of the dead person has to be deleted. Respondent number 3, Bholanath Ghosh.
No. Respondent number 2.
To Madhumay Basu, his name is in your memorandum also. You have not changed. You have filed this appeal in the name of.
Died.
But you have filed this application appeal in the name of Madhumay Basu.
At that point of time, he was alive. When the appeal was filed in 2018.
So you say in the trial court it has been substituted?
Thereafter, he died.
This is against the preliminary decree.
No, against rejection of injunction order and appointment of receiver.
In the suit, his heirs have been implemented. So you have to file a formal application for implement of his heirs also.
He is already on record.
Already on record.
Sudhamay Basu is the legal heir. He is on record. Madhumay Basu died.
There are no other legal heirs.
Yes,
No,
but there are
another
other
one
legal
was
heirs.
there, but the application was rejected in the court. He had another brother.
No, you have to file a proper application for that. Without that, how can it transpires from the envelopes which has returned after attempt to serve on the respondents, that Madhumay Basu, respondent number 2 herein has died. Learned counsel for the appellant submits that the heirs and legal representatives were sought to be substituted in the court below. However, although Sudhamoy Basu, respondent number 1, comma, his legal heir his heir and legal representative is already on record, comma, the substitution application for implement of the other heirs have been dismissed in the court below. Pushed up. However, comma, since the present appeal has been filed in the name of the deceased Mudhumoy Basu as respondent number 2, comma, a formal appropriate application is required to be filed in that regard by the appellant. Pushed up. Accordingly, leave is granted to the.
Five
App-
is also right.
You have filed.
No,
Five.
five.
Before
Respondent
5,
number
you
five.
do it, my lord.
An appropriate application is required to be filed by the appellants in that regard. Push up. Furthermore, comma, it transpires that respondent number 5 in the appeal has also met his demise. Push up. Accordingly, the appellant shall file such appropriate applications for implement stroke substitution of the heirs and legal representatives of the names of the deceased respondents at the earliest. Full stop. Let the matter go out of the list for the present, with liberty to the parties to mention such applications as and when filed for inclusion in the list.
My lord,
Affidavit of service filed to the victim.
distribution application.
No, in the name of dead person, you cannot do anything. You file the applications, immediately mention, we'll include it, hear it out, lock, stock, barrel. Give copies to Mr. Nondi before that.
Simply allow me to give the copy to learned advocate appearing in the court below. For the
Where is the question of allowing? Here, he's appearing, give a
I
copy.
do not know, my lord.
And don't give any copy to Mr. Bosumodi.
No,
He's
I
not.
am appearing for the receiver in the court below. So, my lord, I do not know whether he has made
He's not a
party in
party.
this.
No, he's not a party.
Why has the receiver not been made a party? If
But
the
his
receiver is in
allegation
control,
is
if you are seeking injunction, then
At the time of injunction, he was not appointed as receiver.
now he is the receiver.
Yes,
So if an injunction order is,
last 8 years, my lord.
Yes.
if an injunction order is passed, he is affected. I mean, the receiver is in charge of the interest of the property.
Yes, my lord.
The injunction affects the receiver also. The receiver is representing the estate now.
Let him make an application for addition.
Why should he? Your appeal is defective. আরেকটা লাইন অ্যাড করে দিন ওটা at this juncture, comma, Mr. Bosumulli, comma, learned advocate having instruction to appear for the receiver who has been appointed in the matter by the appointed in respect of the subject property in the court below, comma, submits that the receiver has apparently not been impleted. However, comma, since we are of the opinion that any order which may be passed in the appeal has a direct bearing on the receiver, comma, since the receiver is supposed to represent the estate at the present juncture, comma, the appellant shall implead the receiver as a party to the appeal and serve copies of all the applications and the memorandum of appeal on the receiver as well, comma, directly or through the receiver's advocate in the court, in this court.
Lordship, grateful.
আচ্ছা, মিস্টার বসু মল্লিকের নামটা না রিসিভার ফর দ্য রিসিভার বলে দেবেন, জাস্ট কোনো পার্টির নাম।
Yes, grateful.
Yes. 6-7, who is appeal?
7, I'm appearing on behalf of the respondent, your lordship.
You are for the
appellant, my lord.
right.
The matter has come over the application which is indicating, my lord, I do not have copy of that application.
Lordship,
Your application, not your application.
But,
sir,
Whose application?
no, your lordship, this scenario is this an old matter. For us also, it's a changed brief, and I also missing some documents regarding the plaintiff and
Whose
written
application is this? At least that much you have.
application is on behalf of the appellant because this is a appeal against an order of decree of eviction against a trespasser. There are two appeals, your lordship. One, they have filed a suit for declaration of their tenancy, against which we have filed a written statement seeking eviction of a trespasser.
counterclaim.
Your counterclaim has been allowed.
Counterclaim
Suit has
allowed,
been
suit
dismissed.
dismissed against both the
Their
appellant
preferred
and
appeal.
preferred appeal.
So if there is no stay, why didn't you execute in the meantime?
So, your lordship, I believe there was an interim order which has been subsequently been continuously being extended.
Yes, what do you say?
Actually, I am not ready.
You have copies of all the applications.
So, lordship, I'm carrying the application, the affidavit in opposition, affidavit in reply as well.
No, I do not, I only have the copy of the.
Please
the
take
paper.
copies from him and
Yes,
come
sir.
back.
Give me 7 days time so that.
Learned counsel for the
One
appellant.
indulgence, your lordship.
Yes.
So, lordship, kindly allow us 2 weeks time because, lordship, I'm missing the plaint as well as written statement in my brief as well.
Wait.
So,
Have you got a copy of the memorandum? You cannot have.
I do not have.
Memorandum you have.
I have a copy of the paper book, a complete set of paper.
Paper book has been prepared.
Yes, my lord.
The application is pending, your lordship. I do not know how.
How could the paper books be prepared? How could there be a direction even?
Kindly give
No,
some
let us check up the.
Right.
You are required to go through the order sheet before appearing.
the order
This is not the
number-
function of the court. You have to apply the
Yes,
code.
my order is there, my lord. It's a part of the paper book in 2019. We'll prepare a formal paper book, my lord, incorporating all the records. Page 144.
Yes, at the application stage, those directions were given.
Possibly, my lord. It's a FA code, FA number, FA number 4 and 5 both have been given on that date, my lord. Can two cans in connectivity with both the appeals are also there.
You have got copies of the paper books.
I have got the copy of the paper book, my lord. I can make copies
yes.
also. For a paper book out of that.
हाँ. Do what this. So then you do you have copies of the paper book? Don't have. Please,
I'll make
please
copies.
make copies and hand over to them. And আমাদের এখানে paper book আছে তো এখানে? আছে? এখানে আছে? Very well. We find from the records that the matter is quite old. Full stop. The two appeals arise respectively out of the dismissal of a suit for declaration of the appellant as a tenant and against the an eviction decree passed in a counterclaim filed by the respondents in the same suit. Full stop. Next para. Learned counsel appearing for the parties submit their inability to assist the court inasmuch as all documents are not available with them. Full stop. It appears that pursuant to previous direction of court, paper books have already been filed and are on record with our file. Full stop. Since the appellant's advocate is carrying such paper books, the learned advocate for the appellant is requested to serve copies of the paper book on his counterpart appearing for the respondents in order to enable the latter to come prepared with the hearing of the appeal. Push up. Since the appeal is already ready for hearing, let the same be listed in the next monthly list along with the applications under the heading hearing.
May I get a copy of the application? I don't have.
Whatever you exchange between yourselves. The next monthly list, it will appear under the heading hearing of, appeal history along with the application. Yes, Mr. Dotto, what is the matter?
According to the respondent.
Respondent.
Suit for partition, preliminary decree.
All the respondents? Oh, respondent, plaintiff respondent.
Yes. Suit for partition.
You have served copies of the application on them?
Yes.
Service on the others was dispensed with?
They are the only caveat.
Acha, caveat. We will dispense with. This is an eviction suit by them?
No, partition.
Oh, partition you have to serve. Then serve copies on all the application.
Preliminary decree.
Preliminary decree will pass the usual ad interim order and
Or commissioner party, application commissioner party is fixed today for hearing.
no, let it continue. We'll permit it to continue, but no final degree shall be done. The usual order. The present appeal has been preferred against a preliminary decree of partition, push up, since copy of the application has already been served on the learned advocate appearing for the plaintiff stroke caveator stroke respondent number 1, service on the said respondent is dispensed with, pushed up. The appellant stroke petitioner shall serve copies of the application on respondent numbers 2 to 10, indicating that the application shall be listed next for hearing on April 8, 2025, when an affidavit of service in that regard shall be filed by the appellant, pushed up. In the till disposal of the application, the learned trial judge shall continue with the final decree proceedings, but shall not draw up any final decree without the prior leave of this court.
Respondent number 3.
That's right. Yes, you appeared on the last. Yes, Mr. Bhattacharya.
But defendant filed the appeal. But defendant 9 was the appellant before lordship. But main contest of defendant.
Reply is being filed. You have filed your opposition.
Yes. On earlier day.
On earlier date you have filed. Sorry, Mr. Bhattacharya, what is the appeal against?
Taken preliminary degree, suit for partition. But no summons was served upon the defendant 9. He was not aware.
You are the defendant number
9.
The appellant is the defendant number, right?
Then, my lord, there is a delay. Though I have pleaded about 1 year, more than 1 year. Around 4th December 2023, because the plaintiff filed another suit from receipt of summons, he got the notice. There's a suit for partition was filed with the same property. But subject matter is, my lord, there are 3 years. Grandmother, the property has devolved. The mother, son, and
That is on the merits, Mr.
that's
Bhattacharya.
all.
So you received notice in the month of December 2023.
No, I did not get any summons
Then how did you come to know?
from another summons of another suit.
That is in the month of December 2023.
4th December 2023.
That is what we are asking you.
Then I applied for certificate copy on 8 January 2024. Then I obtained on 11 January 2024.
Why the 2 months delay, 3 months delay after that?
That is the one
This will not do. What have you?
What
is the explanation given here?
No explanation, nothing, no explanation given. I've given my opposition, my lord.
No substantial justice
No.
without any explanation.
Judgment on.
Some explanation has to be there.
Yes, my lord. What 4, my lord? Can you see, my lord? Paragraph 5. On searching for the honorary court bureau, such and such.
Paragraph
But
5
wrong
of-
back again. Example, such and he has already decreased the preliminary degree, such and such. Then yes, there's a blank. Then I find a supplementary.
At 8 and 9, there is no explanation for that 3 months delay.
No explanation is given, my lord.
Mr. Bhattacharya, now it is settled that yes, even if you have a merit, then also we have to consider this. That there has to be an explanation, even if it's 1 day's delay, repeatedly held by the Supreme Court. Length of delay is not is immaterial.
He came to know for the first time on 4 December.
Yes, para 8 and 9.
Yes,
where is-
yes, I know.
How do you explain the gap?
8 and 9 gap.
Yes,
Para 8 and 9 read out.
Oh, thereafter judgment and degree, the appellant advisor and to prefer an appeal. There is a judgment degree. There are during
So
discussion-
obtaining the judgment and degree in January, you
Yes.
received the advice to prefer
Yes,
appeal.
yes.
Thereafter, you met your advocate in when
Your lawsuit is one of the- it is-
and came to know that it is already time, but that means you met after that.
But I know, my lord. But that is why, my lord, said the suit for partition. But admitted if it is not summons have been served. That
Yes,
is
Mr. Mukherjee, partition suit, what is the
Partition.
use of? Will direct him to file a supplementary affidavit, he'll give some explanation.
I'm not.
Manager deed of gift, he has challenged.
On merit of section 5, my lord. It's up to your losses, my lord, to allow or with some sort of cost or not. And that's up to your losses, my lord. But there is a matter that it's a cryptic applications, my lord, and not properly explained. But sufficient cause is not there. Explanation is not there also. It should be explained properly, my lord.
Learned counsel for the petitioner submits in support of Can 1 of 2024 that the delay of a little more than 1 year is due to the lack of knowledge of the appellant, comma, who was defendant number 9 in the partition suit, comma, the preliminary decree of which has been assailed in the appeal, comma, was never aware of the decree, pushed up next para. It is alleged that no summons of the suit was served on the said defendant, which is denied by learned counsel for the plaintiff stroke respondent number 1. You are for 1 or 3. Sorry, plaintiff for learned counsel for respondent number 3. Who sub next para? Learned counsel for the respondent number 3 further points out that no explanation has been given for the delay in preferring the appeal after the appellant came to know of the after the appellant obtained certified copies of the judgment and decree and before he approached his advocate. First up, we find that the certified copy of the impugned judgment and decree was received in or around the month of January 2024, but the appeal was filed in the month of April 2024.
No, March. 22nd March.
In the month of March 2024. First up, next para. Although there is no specific day-to-day explanation of the delay, comma, on a conjoint reading of paragraphs 8 and 9 of the application, comma, we find that there is some scope of showing lenience in favor of the appellant, inasmuch as the appellant only during the discussion with his advocate came to know that there was a time limit for preferring the appeal and the same had expired since. Full stop, next para. Taking a pragmatic approach and a lenient view, comma, more so since the matter arises out of a partition suit where the cause of action arises continuously, comma, we are of the opinion that shutting out the appellant at the inception would be detrimental to the ends of justice. Full stop. Moreover, comma, we do not find anything to attribute malefides to the appellant in the matter of delay. Accordingly, Can 1 of 2024 is allowed, comma, thereby condoning the delay in preferring FAT 82 of 2024. So what about can 2?
So can 2 was stay. Preliminary pass, but no final degree to the knowledge of the my lord appellant. Paragraph 13 has
Mr.
not yet-
Mukherjee, no final degree has been passed as yet. Usual order then.
Appeal is against the preliminary degree, my lord, partition.
Very well. You have served copies of both the applications?
Yes, yes.
Acha. Next para. Yes.
The plaintiff is not appearing. Mr. Mukherjee's client was defendant number 2.
Even 2 over in the court.
No, in our last order, we had recorded that there is substantial service and all.
Yes,
Regarding.
yes, I have served.
So that service is regarding both the applications. That is what. We'll dispose of the applications. Why keep it? Can 2 of 2024 is an application for stay. Full stop. The appeal arises out of a preliminary decree of partition. Full stop. Upon hearing learned counsel for the appearing parties, comma, we take up the application for disposal since the other respondents, comma, despite substantial service, comma, do not appear at the time of call. Full stop. Keeping since the appeal arises in the context of a preliminary decree, comma, in the event a final decree is drawn up prior to the disposal of the appeal, comma, the same will be rendered infructuous. Full stop. Accordingly, can 2 of 2024 is disposed of by directing the learned trial judge to continue with the final decree proceedings. Full stop. However, comma, no final decree shall be drawn up till disposal of the present appeal without prior leave of this court. Full stop. Next para, there will be no order as to cost. Next para, the appellant shall deposit postal costs for service of notice of respondent numbers 1, 2, and 4 to 9 within a week from date. Pushed up. Service of notice on respondent number 3 is dispensed with in view of appearance of the said respondent through his learned advocate. Pushed up. Next para. The trial court records shall be brought by special messenger at the cost of the appellant, comma, also to be deposited within a week from date. Full stop. However, comma, the learned trial judge shall maintain skeletal records for the limited purpose of continuing with the final degree proceedings. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Full stop. Para. Liberty to the parties to mention the matter for enlistment as and when the same is mention the appeal for enlistment as and when the same is ready for hearing.
Yes, only one thing, my prayer, my lord, may be renewed, my lord, that some cost may be given, any cost for allowing the section 5 of that. As up to your lord.
প্রথমে লিখে দিন প্রথম সব একদম উপরে এফিডেভিট রিপ্লাই ফাইল টু বি কেপ্ট।
Yes, madam, I'm for the petition. Appellant, madam.
What is the application? Yes.
You can see that they appeared. Yes, madam, last time you like to see the order of your lordship.
Yes.
The respondent, my lord.
You are appealing for the respondents. Yes.
My lord, today, my lord, the brief has been handed over.
Nothing can be done. On the last occasion, you had paid for time. That was quite March 10th.
My junior entered appearance.
Whoever, yes, your junior, learned junior, she had instruction to appear, and that's why you could not dispose of the appeal. Now,
At that time, there was no application.
Nothing doing. What is the appeal against? So you will dispose of the application. Learned counsel for the respondents seeks time to stop. However, comma, we find that in our order dated March 10, 2025, comma, we could not dispose of the appeal since the learned advocate for the having instruction for the respondents had sought an adjournment on the said date as well. Full stop. Since the appeal is pending for some time and arises out of a suit which is quite old, comma, we refuse such further prayer of adjournment on behalf of the respondents. Full stop. The appeal has been preferred against the preliminary decree of partition. Full stop. Accordingly, can 1 of 2024 is allowed on contest, comma, thereby directing the learned trial judge to continue with the final degree proceedings, comma, but not to draw any final decree without the prior leave of this court till disposal of the appeal. There will be no order as to cost. Full stop. Next para. You appear for all the respondents?
They are sisters, sir. Three.
Sisters.
All
Very. In view of the appearance of the respondents to their learned advocate, comma, service of notice of appeal on the respondents is dispensed with The trial court records shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Full stop. The learned trial judge, however, shall retain skeletal records for the limited purpose of proceeding with the final degree proceedings. Full stop. Next para. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Puts up liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. Thank you.
My lord, I beg to appear on behalf of the
Yes. Just make it short today because we want to finish this matter. It's going on for quite some time. Come to the points, and you have already argued. And what are the rest of the points?
Yes, my lord.
What does your client do, and what is his qualification? We were just asking.
My lord, my client works in the United States of America. He is an NVH mechanical engineer. He's a senior engineer, works as an NVH.
What is NVH?
Noise vibration engineer. That is with regards to automobiles.
Where?
So he works as a mechanic with regards to automobiles.
In which company?
In Zooks.
Where?
That is categorically in my affidavit.
Yes, obviously it must have been.
Now, Your Lordship, the points which had been proved yesterday, I shall just give a pinpoint view that the wife is well educated, she is able-bodied, and she is earning. Next is that the wife runs a business with one Neha Bajoria in the name and style of ABN Designs, and also has advertised the same through a paid membership platform called BNI.
Acha, can you please just remind us about the page number, Mr. Mohta, of where it appears that she is the owner, and
Yes.
that page only. The other pages we have it marked somewhere. Yes.
Absolutely. Yeah.
Just tell us where it is shown as owner.
Page number 133, Your Lordship.
Of your AO.
Of my affidavit in opposition. Page 133, wherein it shows that she's the owner and founder of ABN Design.
That's a Facebook post.
That is the Facebook post.
Or LinkedIn, probably.
LinkedIn also it shows, my lord, and also reiterates in Facebook.
Yes.
Your Lordship, it has also been proved that the wife used to work before marriage and even after separation was working and has the capacity to earn and can work. Your Lordship, rent to the tune of rupees 40,000 does not tally with her bank account statements. These are the facts which, my lord, I have proved. Now, my lord, with regards to suppression of material facts, my lord, I shall just place a judgment and I shall mention the relevant paragraphs. I shall not go on with the dealings of.
She has said that she doesn't have any income at all apart from that mention.
She has said that she is living at the mercy of her parents. She's a homemaker and she does not have any particular income. I've categorically proven that she has income. Sir.
All right. Yes.
Clean hand doctrine is judgment. Now, my lord, it is well settled, my lord, that a person should come with clean hands or else adverse inference will be brought into play, my lord. For that particular, my lord, I refer to this particular relevant paragraphs, my lord, paragraph 21 to 20.
Give the citation for him.
I have already given a copy, my lord. The paragraph 21 to 29, my lords, I keep my submissions to that. Now, my lord, coming to
Yes.
now, my lord, coming to that, yesterday what I had said that this is an application for alimony for the very first time in an appellate stage was never preferred in the trial court proceedings. My specific submission is that an application for alimony is independent of divorce proceedings and it can also be filed in the lower court. Now, for that, my lord, I'm relying on this.
So you're trying to say that she did not have any need for money during the trial?
Yes. And that is the reason that.
But she had the domestic violence proceeding.
Yes,
that order.
She had the domestic violence proceeding and she was getting 60,000 rupees, which was 60,000 rupees as maintenance and 60,000 rupees as arrear. Now, because
so since she had that, there was no necessity for her to file an additional application. But the law is clear that the higher amount shall be paid.
Absolutely, my lord. But my lord, what my submission is with regards to section 36 of the Special Marriage Act, my lord, which says that section 36 is independent in itself. So even if an alimony application has to be preferred, it can also be preferred in the trial court. There was no need to file it for the very first time in the appellate court without going through the process of the trial court proceedings.
All right, yes.
Now for that particular reason, my lord, I'm relying on this particular judgment, my lord. Copy to these. My lord, paragraphs 46 and 48 is what I'm pressing upon, my lords.
46 and 49?
46 and 48, my lord.
48, yes.
46 and 48.
This was a section 25 case.
Yes, my lord. This is a section 25 case, but however, Hindu Marriage Act and Special Marriage Act.
No,
my lord,
the
there are
acts are similar, but section 25 is permanent alimony. The suit is still continuing.
My lord, this is with
The
regards
other,
to-
it's deemed to be
one and the same thing, my lord. I understand, but it is one and the same thing, my lord.
because that stage has not yet come.
That
If she
stage has not
obtained
yet
a divorce decree, then it would be section 25.
Correct, my
But
lord.
it's where the principle applies.
The principle applies, my lord.
Here it was held that in the absence of any application under section 25, no permanent alimony can be granted.
Correct, my lord. Now, my lord, the thing is that if section 25 is with regards to permanent alimony, there is also a section which deals with interim alimony.
Yes.
So, my lord, any application which was not preferred in the trial court cannot be preferred for the very first time in an appellate court because they're trying to make it out as a new case. Now, this case was never made out in the trial court. Now, they're making out a new case from a divorce simpliciter proceedings to a money recovery proceeding by way of this CAN application.
All
That
right.
is my submission, my lord. Now, my lord, now let us come to the moot point, my lord, of grant and non-grant of the alimony which the wife is seeking for, my lords. Now, my lords, for that particular, my lord, this is the judgment which I rely upon, my lord, the first judgment which I rely upon. My lordship, specific paragraphs, my lord, paragraphs 20, 24, 27, 30 and 31, my lord.
What is the proposition basically?
Now, my lord, in this particular, my lord, kindly comes to paragraph 21, my lord.
20, yes. Page 14.
Now, my lord, I shall just recite this particular judgment, my lord. Rest of the judgments do not need to be recited, my lord. Now, my lord, my specific submission is what has been reiterated by the counsel for the husband, that the present appeal proceedings is being converted by the appellant wife into recovery proceedings as if the appellant wife is entitled to recover a fixed sum from the respondents towards permanent alimony. Now, my lord, this is also with regards to permanent alimony, but however, the principle applies, my lord.
What was that proceeding which was being sought to be converted?
The appeal, my lord. Now, my lord, they had filed a permanent alimony application, my lord, which was rejected. The grounds of rejection, my lord, is that the wife is resourceful, she was earning.
There the temporary alimony pendentity was dismissed.
Yes, my lord.
Then it's a different circumstance.
They had filed it, my lord. That
if that filed it was dismissed, it would be otherwise.
Right, my lord.
The principle of res judicata might operate.
Not the principle of res judicata, my lord. The trial court had rejected the application for permanent alimony with regards to that.
Permanent alimony was rejected.
Yes. With regards,
they had not filed any temporary alimony application.
No, my lord.
So against that, this appeal was preferred.
Yes, my lord. Yes, my lord. Now, my lord, kindly comes to paragraph 24, my lord.
Yes.
Now, my lord, kindly turns the page, my lord.
Yes.
My lord, 7th line after the full stop, wherein it starts from at the same time.
Yes.
Now, my lord, it is stated at the same time, it cannot be used as a tool by one of the spouses to elevate the status and standard at par with each other, the financial status of the husband or wife, can be taken note of by the court only for fixation of quantum of maintenance and is not a criteria for matching the financial status of one of the spouse with the other.
But this is contrary to law. Supreme Court repeatedly says that it has to be commensurate with the lifestyle of the other spouse.
Definitely, my lords. Now,
yes, but there has to be a balance between the
there
two.
has to be
Just
a
because you are earning more, she is not entitled.
absolutely, that is
Very good.
that
Get
is
the
where I
point.
all upon
Get
my
the point.
submission, my lords. Now, my lords, kindly comes to paragraph 27, and I will rest my case, my lord. Rest my case with respect to this particular judgment, ma'am.
When will you rest your case totally?
My lord,
How long?
10 minutes, my lord. 10
Very
minutes by the clock, my lord.
Very good. 27.
27. Now, my lord, kindly sees the ratio laid down by the Supreme Court in the above case, Sri case, has to be applied in the light of the facts and circumstances of this case. We are not oblivious to the fact that the permanent alimony to be fixed is such that will result in the other spouse to lead a luxurious life at the cost of the other spouse. At the same time, it must be ensured that the refusal of permanent alimony, the other spouse will be left in penury with any financial resource to lead a basic life. Now, my lord, the grant and non-grant of alimony is to take into consideration that the wife is not left destitute, is not left for vagrancy, and her basic necessities are taken well care of. Also, your lordship, thus the entitlement of the wife to get permanent alimony is not axiomistic following the decree of divorce. Now, your lordship, after 2 lines, your lordship, what the court has said
Need-based.
is that it should be need based and not monetary based, and also the learned judge was very empathic to the fact that the person who is working specifically in service, my lord, my client is working in service, he has his attendance register, my lord, he has to go every day, it is hard and sweat and money, my lord, he goes there, he has to work, he earns it by hard and sweat and money, and that has to be taken into consideration is what the learned court here is saying, my lord, that it is needless to mention that for any of the spouse to earn income through employment, one has to put in hard labor throughout the month, fulfill the tasks assigned to him by the employer, remain in attendance for any of the assignments at all times, keep himself abreast with the nuisances of the work, etc., to survive his employment. While so, the permanent alimony is fixed with regards to must take into consideration to the hard labor put in by one spouse to earn the income. My lord, it cannot be a submission that the husband is working in the USA, this is his income.
Just because that
how he's earning, and that is the only categorical government which has been taken, and 1/3 of which has been calculated. Now, that calculation is also wrong, my lord. That also, my lord, I will prove.
Now, the amount disclosed in there, that chart is correct, that the amount of your income which is
My lord, that is
not
that,
the 1/3 calculation, the amount disclosed by you, that
the
is
amount
correct.
disclosed, yes, my lord, but they are taking into consideration a very wrong amount, my lord, and 1/3 of a very wrong amount has been taken
Why
into
wrong?
consideration, my lord. Now, my lord, why, my lord, my lord, I'll come to that at
When
the
you come,
at the
yes.
very last, my lord.
Very.
Now, my lord, coming to my basic last submission, my lord, that a case which is not pleaded in a lower court, my lord, cannot be pleaded in an appellate court for the very first time, my lord.
Repetition.
Okay, copy. Now, my lord, I shall just put in the relevant paragraphs, my lord.